Good morning, viewers. Welcome to Konosima Short Time Classes. Get ready. This is 80 words per minute legal dictation. 5 seconds. Start. Disputes as to immovable property. Application under Section 145 CRPC. Section 145 falls in Chapter 10 of the Code, which deals with serious and urgent matters connected with the maintenance of public order and tranquility. The proceedings have positive nexus with public tranquility and they need earliest disposal to allay fears, anxieties, and panic of the contending parties and other connected with such disputes. Proceedings under Section 145 of the Code can be invoked when a dispute exists concerning any land which is likely to cause breach of the peace. Land includes building as well as an order under Section 145 is just a stopgap or a provisional order that lasts until the right title and interest in respect of the disputed property are finally determined by a competent civil court. In Section 145, the language used is that dispute likely to cause a breach of peace exists. It is not that the breach should have necessarily taken place. What has to be considered is whether there is any dispute between the parties which may cause apprehension of likely breach of peace. In substance and effect, a proceeding under Section 145 is primarily concerned with the prevention of the breach of peace by declaring the party found in possession to be entitled to remain in possession until evicted therefrom by due course of law. In case the magistrate is able to declare possession of either party on a consideration of the material before him, he would do so, and in that event, he is to pass final order under Section 145. The magistrate then will have to withdraw the attachment in accordance with the proviso. It is only when genuine difficulties arise that a magistrate can, for good reasons recorded in writing, decide that it is not possible for him to decide which of the contending parties was in possession of the subject of dispute on the date of the preliminary order. At that stage, it is open to him to pass an order under Section 146 of the Code to attach the subject of dispute until a competent court has determined the rights of the parties thereto with regard to the person entitled to the possession thereof. Of course, if he has earlier thereto at any stage attached the property in dispute, he can continue the attachment till a competent court has determined the rights of the parties thereto. A finding of existence of breach of the peace is not necessary at the time when a final order is passed, nor is there any provision in the court requiring such a finding in the final order. The primary object of this provision is to settle the matter temporarily so far as the criminal courts are concerned and determine the question as to which of the parties was in actual possession at the date of the preliminary order. The object is only to prevent breach of peace.